Hello, I'm Andy Agathangelo. I'm the founder of campaign group Transparency Task Force. We advocate for the consumer interest. Our purpose is to promote reform of the financial sector so it serves society better. We are a UK-based certified social enterprise, but we do have people in some way involved with our work in 20 countries around the world. Each week, we publish the Transparency Times, which is our newsletter. And most weeks, we run events like the one we're having tonight. These are attempts to raise awareness of issues or opportunities amongst our community, amongst our membership. Tonight's session is, I think, the third or possibly the fourth event we've run to do with litigants in person. Litigants in person, of course, are people who, for one reason or another, are finding themselves working their way through a judicial process or possibly a tribunal process, unrepresented, without the benefit of a lawyer or a barrister, typically because they don't have the funds to pay for such a person and therefore find themselves, frankly, often very, very well and truly significantly out of their depth. So we decided to start focusing on the litigants in person issue about 2 years ago because we wanted to do all we could to try to help people who are having these David versus Goliath battles in the court. Tonight's speaker is Becky Newman. Becky is a key person in a tremendous charity called Support Through Court. It really does do exactly what it says on the tin, so to speak. It's an award-winning charity that provides practical and emotional support. And that last bit's very important, practical and emotional support to people navigating court proceedings without legal representation. Support Through Court helps individuals understand court processes, complete forms, organize documents, and feel more confident before, during, and after hearings. The volunteers support thousands of people each year across England and Wales, ensuring that no one has to face court alone. Alongside hearing from Support Through Court, we'll also be hearing from members of the Transparency Task Force community, both in the UK and in Ireland, talking about their lived experience, trying to pass on the hard-earned nuggets of wisdom that they feel may be of benefit to others as well. The event will hopefully offer valuable insights, access to justice, the realities faced by self-represented litigants, and the vital role of support services within the legal system. Can I please invite everybody to show their appreciation to Becky, who's here with us tonight? Becky has spent time preparing the presentation, preparing a slide deck for you all that she will also be sharing after the event as a PDF. Can I please invite you, please, now to put your hands together and show your appreciation to Becky, who's our keynote speaker tonight. When you're ready, Becky, please take yourself off mute and I'll get the slide deck ready for you. And just tell me when you want me to move from one slide to another. Becky, please do unmute and we'll get the slide deck up and running now. Thank you.
Thank you, Andy. Good afternoon, everybody. Thank you to Transparency Task Force and for Andy and the team allowing me to speak this evening to share a little bit of insight into our organisation, what we do, and also to hopefully share a bit of best practice and also for myself to understand your insights as well in terms of your experiences and also other organisations that we can also signpost to in terms of the clients that come and see us. So in terms of the organisation, I've worked for the organisation probably for over 8 years now. I came in as a volunteer. My current role is Senior Service Manager. I've been in the role since July 2024. I support the wider team and our head of service delivery, but I also run the Manchester service. We run a hybrid service. We're based in the Manchester Civil Justice Centre. We also are partnered with Manchester Metropolitan University, so we can provide appointments for clients in person in our offices in the courts, and also facilitate telephone and Teams appointments. Andy, if you can go to the next slide, thank you. So Andy's given you a little bit of an insight into the organisation, but we are a independent national charity offering practical and emotional support to litigants in person, mainly facing family and civil proceedings. We're volunteer-led. We have nationally around 1,000 volunteers. That consists of core volunteers, so retired professionals, and also student volunteers, usually that are facilitating or studying a law degree or further study. Our aim really is to help clients to feel clearer about what they need to do when they have no option but to represent themselves, whether or not, as Andy mentioned, they've already had legal representation and can no longer afford to continue, or whether they have decided to start to represent themselves from the beginning. We do try and ensure that those facing court alone are feeling more prepared and supported when accessing justice, and really our ethos is to empower clients to manage their cases for themselves. Last year, our general feedback across the organisation was 96% of clients said that our volunteers help them make procedures clearer, help them feel better prepared, manage their anxiety, and help them feel calmer when they're particularly going into hearings and advocating for themselves. Next slide. Thank you. So just to give you an understanding in terms of what we can and what we can't do, we offer support and guidance before, during and after court, providing information in terms of helping litigants feel more prepared in terms of what to expect when they're going into court, how to prepare, what to expect when to go into a hearing, how to address a judge, for example, just so they can best represent themselves with really dignity and self-assurance. We can provide practical and procedural information, explain what happens when clients go into court, particularly from my experience when we're supporting in the Manchester Civil Justice Centre. It's a huge building. You have to come through security when you go in. It can be really very daunting, especially when, as a litigant, you're probably going through quite a vulnerable and emotionally charged period of your life. So just to have that reassurance is really quite vital and really beneficial in terms of empowering litigants to feel calmer and more prepared. So we can help fill in forms. We can help format witness statements, for example. Our service is free and really open to anyone who needs that support, providing that it's within the remit that we can help with. We hope to listen to each client's individual story, so they can decide on the next steps. And really, again, today, our partnerships with legal clinics, not just in Manchester, but across the country, and third sector organisations, enable us to source complementary specialist support for people. For example, if people need support, if they're in a domestically abusive relationship, for example, if they're facing homelessness, if they need that specialist legal advice to really try and create that partnership with other organisations so we can effectively signpost. Next slide, thank you. So in terms of what we can't support with, we can't act on clients' behalf, so we can't speak for clients in hearings, we can't phone the courts or potentially the other party's representation on behalf of clients, or submit forms to the court on a client's behalf. We can't do casework. So again, really our main support is to empower the litigant to represent themselves effectively. We can't tell clients what to write on forms, so we can help people put their thoughts down on a form, but we can't dictate what to write or what particular form to fill in, but we can provide that procedural support. Again, really, when we're supporting in person, we can't look after clients' children or vulnerable adults, or look after belongings when we're supporting in the court buildings across the country. And we don't share clients' confidential information unless there's a significant safeguarding concern that's been raised. We also can't act as witnesses to investigations unless there's a court order in place summoning us to act as a witness. But in the time I've worked for the organisation, that's never been raised. Next slide, please. Thank you. So just to give you an understanding, I mean, this is different across different offices, but particularly in Manchester. I know this may not be the focus of this discussion, but in terms of the main case background that we support is really with family proceedings. So that's if a client wants to make an application for contact with their children, if they need support making the initial application, if they need support with referrals to mediation services, what to expect with the first hearing and how to effectively contact the courts in terms of information and what to look out for. So 52%, but really in Manchester, it's more like 70% of people that we support is the case backgrounds with regards to family. We do help with divorce proceedings. We can also help with the application to notify the court that wants to start financial proceedings as well, in terms of severing financial ties. And we can also support both survivors and alleged perpetrators in non-molestation proceedings. So if one party is experiencing harassment from a close family member, just to provide that protection, we can help with that application as well. In terms of civil cases, we can help with small claims up to £10,000. We can also help with tenants that are facing possession proceedings with the landlords, or if they're facing eviction proceedings. We can also support landlords as well if they want help with certain forms. Again, we're limited in terms of the advice. We don't provide legal advice, but we can certainly try and signpost where appropriate. Next slide, please. Thank you. So I'm not sure whether this is a little bit blurry, but again, this can be available. This is available on our website, and also I've shared information with Andy and Alex in terms of resources that they've also included on their page as well. But it just gives you an understanding about what we can and can't help with in terms of providing practical support. I know Alex did send me a list of points that people were hoping to understand, but in terms of things like judicial reviews, medical negligence, personal injury, just because the cases are very complex, we would advise that you'd need to seek some specialist legal advice in terms of if you are going to initiate a claim, for example, just to understand a likelihood of success before starting an application based on the cost, as again we'll probably discuss later on as well. Next slide, thank you. So just to give you an understanding in terms of not just Manchester but nationally, we have face-to-face offices across the country in main cities across England and Wales. We also have a national helpline, which I can give you the number for in a moment. And we also have a support through court online. So for example, if you've got a remote hearing, or if court users want to access our services but there isn't an in-person office in their locations, they can at least access support remotely. Again, if face-to-face services are booked up and a client needs support and it's time sensitive, our helpline is brilliant in terms of accessing support there and then. Next slide, thank you. And this is our details. Again, this is available on our website, and we can share this information after as well. But our national helpline and most services are open Monday to Friday, 9:30 till 4:30. Also on our website, if clients need to book appointments, you can also do that through our website as well. Next slide, thank you. So just in terms of the title of this meeting, in terms of the challenges that we see in Manchester, but also across the organisation, challenges that litigants in person face. Just a couple of examples, but high legal costs in terms of getting that assistance is unaffordable for many people. Particularly a lot of the clients that we support might either be on low income or claiming particular benefits, just in terms of not only accessing a representation, but even the cost of certain court applications, given inflation as well. It's just getting more and more expensive. So there is, in terms of a challenge, in terms of high legal fees, more and more people are having to represent themselves. I think I've attended a talk a couple of months ago where a High Court judge mentioned that just in terms of beginning family proceedings, 70% of the cases that are coming through the family courts, people are representing themselves due to lack of funds or ability to afford legal representation. So it is a growing challenge and a growing issue that people are facing without a lot of support, given that legal aid has drastically been cut. Again, the complexity of legal procedures, legal jargon, just to try and navigate the family or civil procedure rules is very challenging. The wording, for example, if court users get a court order that could be like 4 or 5 pages long, particularly if they have literacy issues or English isn't their first language, it's really difficult for people to understand what they potentially need to do, think about next steps, and also given the time frame with regards to potentially getting certain documents sent to the court within a particular time frame that allows their proceedings to continue effectively. So that's another issue. Delay in proceedings is difficult. Again, the courts have now outsourced local numbers to a national helpline, which can take considerably long to get through to speak to anybody. Again, if you don't have access to your case number or the parties in proceedings, it's very difficult to get the information and update on your case. I haven't mentioned it in this presentation, but there's something that Andy mentioned is the difficulty in relying on AI in terms of out-of-date information, incorrect information, particularly if you're relying on AI to give you procedural information. You just need to be careful that you're making sure that you're cross-referencing that information and looking at public resources. Making sure that, I'll go into useful information afterwards, but certainly making sure that if you are relying on certain information, you're backing it up with public resources that are giving up-to-date information in terms of opening hours, email access, and numbers that you can get through to people to make sure your information is getting to the right person. And again, finally, emotional and psychological stress. A lot of the people that we support are very vulnerable. They're going through very difficult periods in their lives. It's really important, and something that we try and support people with is to look after their own mental health when they're going through court proceedings, to try and separate the emotional aspect, which is easier said than done, particularly if you're facing loss of your house, for example, particularly if you're facing homelessness and there isn't that support available. It's really important to make sure that you're looking after your mental well-being. And then again, unequal resources between parties. Andy mentioned the David and Goliath situation, particularly if you're representing yourself and the other party might be a big financial organisation, for example, a bank, and they've got 3-4 barristers and unlimited financial resources. It can be extremely overwhelming. So again, that's another challenge that we see clients facing when they're accessing our services. Next slide. Thank you, Andy. I've already mentioned this, but again, litigation can be extremely emotionally taxing, exhausting, particularly if you're trying to manage your day-to-day lives as well, in terms of keeping down employment or supporting your families. It can lead to emotional exhaustion. Again, representing yourself can also bring up all sorts of emotion, anger, affect your confidence, your self-esteem, increase anxiety, particularly if there's a significant financial loss attached to losing your case. So again, I've just put together a couple of resources. Again, the Transparency Task Force website has got a plethora of useful resources. I think what we would already signpost as an organisation ourselves, so I'll let Andy discuss that a little bit later, but there's a lot of resources on there as well. But just a couple of organisations that you might already be aware of. Next slide, Andy, please. Thank you. Mind, Samaritans, and NHS 111, just organisations that you can access, or clients can access if they need support with their mental health, particularly if the court proceedings generally are just very overwhelming. People are never on their own. There's always resources and people that you can talk to in a safe environment, just to offload in an anonymous, safe setting. So I really would encourage, we do encourage clients, if they are facing mental health difficulties, to reach out to organisations such as these to get that support for their mental health. And just finally, the last issue I was going to mention again, as an organisation, we don't support with criminal issues, and probably Andy and Alex have more understanding of victims of financial or fraud than I do, but just a couple of things that I've looked up in terms of if you are a victim or if someone does become a victim, just these typical steps in terms of contacting your bank or card provider, changing your passwords, monitoring credit reports, reporting fraud to the authorities. I think, sorry, next slide, Andy, thank you. I think, again, this is on TTF website as well, but I think report fraud has changed from action fraud recently. I've just looked that up a couple of days ago. So
Yep.
is that right? Thank you. The Financial Conduct Authority, in terms of reporting any fraud you've faced, and also Victim Support is a brilliant organisation again that can provide support for victims of crime as well, which again, all of this information is on your website, on the TTF website as well. Thank you. I'll hand back to
Fantastic.
Andy. Thank you.
Becky, thank you. Can we show our appreciation again to Becky for taking time to be with us and going through that? Becky, that was excellent. Such a clear explanation of what your organization is, why it exists, what it does, and how people can benefit, but also, very, very importantly, what you don't provide, and for good reasons. It's good for people to be able to understand that. Becky, if you don't mind, I've got a couple of questions for you before we'll invite we'll invite others to ask you questions or make comments. And then what we're going to do is to go to three sort of additional speakers who'll be chipping in with input as well. We're going to be going to Tony Lawler, to Arnaud Gaultier, and also to Edward Romain as well. I think this will broaden the conversation out a little bit, and it might be particularly interesting for you, Becky, to understand what these folks have learned through their lived experience. But Becky, my first question to you is: you talked about people being vulnerable through the process. Um, I've attended a couple of court hearings in the last year or so. And in both cases, I think it would be fair to say that the people I was attending the hearings with and for were vulnerable in my mind. There were people suffering huge amounts of anxiety and stress and worry. They weren't being treated fairly, as far as I could see. Does the judicial system in the UK in some way accommodate for the fact that some people might be vulnerable? Do the courts kind of take that into account in some way, to be a bit more human about how they're dealt with? That's not a particularly well framed question, Becky, but you can probably get a feel for the kind of thing I'm asking here. Any thoughts on that one, please, Becky? Thank you.
I think it's a balance. I think it's again for the responsibility of the litigant to ensure that they're keeping up with communications from the courts, that they're taking the responsibility to engage, that they're making sure that the right documents and the right information is being sent to the courts, and that the courts have accurate contact details to contact them, for example. But then also the outsourcing of resources to the national number does cause delays in terms of trying and access the courts and getting an update on your case. I also think there could be an improvement in terms of litigants being aware of the special measures that they might be entitled to. For example, if English isn't their first language and they need an interpreter, people sometimes don't know that that's can be requested and an application can be made in terms of the courts to facilitate an interpreter. So obviously, that's a barrier to their access to justice. Again, if they require special measures for a particular disability or need that support, so for example, processing information, they might need a little bit longer, or they might need specialist IT to help them navigate their evidence appropriately. That's something that more could be done in terms of making litigants aware that these measures can be applied for, and that support
Wonderful.
should be provided. Yeah. Has that answered your question? Sorry, Anne.
It certainly has. It certainly has. I'm so keen to read out something that's been put in the chat. Bear with me, folks, while I just reference something that's been put in the chat. It's so lovely to read it. So it's a comment by Carolyn Francis. You've got a real fan here, Carolyn. Sorry, Becky, in Carolyn. Carolyn says, I'd like to say how much support through court helped me through a recent case I brought against the local company. The defendants hired a national solicitor, and I, without one, felt very intimidated. Support through court were always available and gave me tremendous support throughout, online and by phone. In the end, after a year-long wait for a hearing, I had to drop the case. I just couldn't justify the mental and emotional toll of resurrecting and marshalling all the complex evidence again, not to mention the time. But I did manage to negotiate a drop hands offer, meaning they had to pay their own legal fees and other costs. I learned such a lot, and none of this would have been possible without support through court. A huge thank you and total recommendation. Karen, it's so nice to read that out. And thank you so much, Caroline, for taking the time to write that into the chat for us all to learn about. Quick question from Andrew Wernick. Becky, do you help tribunals such as Residential Property Tribunal, and do you provide help when there is a discrimination by a judge to a litigant in person? Any thoughts on either of those, please, Becky?
So we don't help with tribunals.
Okay.
If I will say that in terms of just accessing forms, um, the government website is a really useful, up-to-date resource. I mean, that everyone might not share this, but certainly just generally, I think it's a really useful resource that in this country we're quite lucky to have. In terms of if you feel that you've been treated unfairly by the judiciary, you can make a complaint. But again, I don't know whether that you'd have to show that there's been some kind of error in the application of the law rather than because the case hasn't gone in a person's favor. I mean, that's not very helpful. But in terms of if you wanted to raise, if you felt or been treated unfairly, there are processes that you can and a process that you can follow in terms of raising that with the judiciary. Yes.
Becky, thank you very much indeed. There may be other comments or questions that come to mind before we wrap the session up. We're planning to finish at around 7 p.m. UK time, folks. That's about 25 minutes or so. But before we get to there, we're going to hear from Tony Lawler. We're going to hear from Arnaud Gaultier, both of whom have amassed a huge amount of lived experience in terms of handling stuff in the courts. I think you'll find what they all say very interesting. And we're also going to hear from Edward Romain as well. Very good to have you with us as well, Edward. So, Becky, thanks again for what you've covered so far. It's been tremendously helpful, very, very clear, and frankly, very. I wish we knew about you 10 years ago, Becky. I mean, that's the conclusion I'm coming to. It would have been so great to know about you 10 years ago. Thank you. Tony Lawler, Tony, please take the mic and introduce yourself and just share whatever thoughts come to you about what could help litigants in person. For those of you that don't know Tony, Tony is a very significant part of our community in Ireland. Tony attends most, if not all, of our weekly Wednesday meetings for what we call the Ireland Matters Group. Over to you, Tony, to share your pearls of wisdom from your lived experience. Tony Lawler to you, sir. Thank you.
Thanks, Andy. Um, First of all, I agree and I see a huge benefit in what Becky is after saying there. But from listening to her, what she's saying and what I know brings to my mind uh, the real world uh, and the ideal world. Becky speaks very eloquently of the ideal world. She mentions vulnerability, she mentions mental health, she mentions several different areas where help can be got and secured and all that sort of thing, which is very welcome information. But unfortunately, that is not reflected in the real world. In the real world, the likes of now, I'm only speaking from the banking point of view. In the real world, they don't give a rat's behind about um, equity of arms. If you were going in there as a lay litigant, they're going in there with three or four barristers and a solicitor and all this sort of thing. They don't care. That's something they don't care about. They don't care about your vulnerability. They don't care about your mental health. They don't care about uh, about the case itself. What they care about is getting a result and how they get that result. Now, we have, Andy, in TTF discussed over the last number of years the whole thing about information control and how it shapes narratives and how it shapes results and all these sort of things. And like, there's a few things that come to mind to me that we really need to get a better understanding of, and that is their playbook. It's all very fine saying that all these supports are there for you. But we need to learn how to play their game. We need to understand their game. And just let me give you one or two examples that
Please do.
come to
Yeah.
mind. Standard financial statement, right? A standard financial statement, that's the very first thing that will be shown to the judge to show that you can't pay your bill, and they're asking you to fill in that, and you think you're filling it in, and these people are going to have sympathy on you that, oh, you have all these bills and your wife is after losing her job and there's somebody sick in the house. They don't care about that, Andy. They don't give a tuppenny damn about that sort of thing. Another purpose of a standard financial statement, if there is a question mark over the statute of limitations, which provides a certain amount of time in which these people can bring their case before the court. Now, if the statute of limitations has expired, by then getting you to fill in a standard financial statement, that's acknowledging the debt. That creates another limitation period. Now we need to wise up to the game rather than anything. Like, there's so many different examples. The likes of you got independent legal advice. Well, if we got free or if we got independent advice, why don't they publish the legal advice that we were given? Because it's only a diversion. And all these procedural rules that are shaped. And like, the best example that I can give what's going on here in Ireland is this summary versus plenary proceedings that takes place. Like, summary, to put summary and pleading and plenary against one another, one v the other. One controls all the information, and the second has the potential to discover more information. So why in the name of God would we accept a summary jurisdiction that limits the amount of information that we can discover and that shapes the jurisdiction of the court? But that will not, like, you try to bring in some piece of evidence that you have in the summary proceedings. All is they're going to say, they're going to object to that straight away. Like, in my own case, we say, for example, when I went into the Court of Appeal, in the High Court, on my appeal from the Circuit Court, I had my affidavit drawn up, and I had a whole list of different uh, things that were relevant to my case. and the judge wouldn't open my affidavit in the court. Now, you ask yourself why? Why didn't he open my affidavit in court? If he had to open my affidavit in court, all the issues that were in the affidavit and that were pleaded in the affidavit will all have to be dealt with. He'd have to deal with them one by one. So he wasn't going to do that. And this is the game. This is the game that these lads are playing, to find ways around how to keep certain information out of the way of view of the court. Like when I was asked about the standard financial statement, I said to him, now, if you don't fill out the financial statement, these people will go into the court and say that you're not cooperating with the process. And you could get a judgment given to you in default because you're not cooperating with the process, right? But I was thinking about this. So I wrote back to him and it says, absolutely, once you confirm for me in writing to me and to my legal representative that the financial statement I will be given to you is without prejudice. So they wouldn't be able to use it in court. They wouldn't be able to hand it up to the judge. It's just to give them an idea of what the did I get that? No. The minute
No.
they heard that it was without prejudice, all of a sudden it was dropped. The instance was dropped. And Andy, you know as well as I do, I was actually looking at you this morning, believe it or not. At 5 o'clock in the morning, I was looking at your contribution when you made that award to Hester Bias.
Yeah.
And I was looking at that contribution there this morning. And that's it, Andy. That's it in a nutshell.
Mm.
What's going on in our
So thank you.
financial.
Thank you. For those of you that don't know, Hester
Thank
is a Dutch lawyer who
you.
has um, very bravely exposed very serious banking misconduct across Europe, and she's put herself at risk as a whistleblower. She's a lawyer, and she's been battling in the courts. Tony, one more quick point from you,
Could
please,
I just
before.
make Sophie?
But bear with me, Bajella, bear with me. We're a little bit tight on time at the minute.
It's
So, Tony,
important.
one more quick point from you, please, Tony, before we pass over to Arno, and then to Edward, and then we'll see if there's time for some others to chip in as well. One more quick point from you, Tony, please. Thank you
Well,
very
if
much.
I
Thank you.
was, if I was Andy, if I was asked to contribute to the litigants in person, I would be suggesting to every one of them is to learn their game, learn the playbook.
Thank you very much indeed, Tony. A lot of hard-earned, serious, heavy-duty lived experience, and it's a shame that it's only tends to be the folks in Ireland who hear about Tony and his work. But thank you very much, Tony, for that contribution. I think Tony makes a good point. There is a difference between how things are supposed to work in theory and how they actually work in reality, particularly in Ireland. We're now going to go to Arno, who is French, but we know Arno through our Ireland Matters connection as well. Arno, we need to manage time reasonably tightly, so we've got about 5, 6, 7 minutes or so. We'll then go to Edward. We'll then go to Magella, who wanted to chip in as well, and hopefully we'll have time for a few other comments and questions before we wrap up at around 7 p.m. So Arno, you know what I always say, the concise version, if you could, sir. Thank you very much. Thank you.
Good evening, everybody. Thanks, Andy, for having me.
Uh-huh.
Thanks to Becky and Tony for their lovely presentation. And as I was invited, I'm going to make I am first chairman of Open Justice Ireland, which aim as the principle of Open Justice is to ensure the scrutiny of the judicial process. And that relate to what Becky was talking about when we think about making complaints against judges who treat litigant in person unfairly. And in that regard, the people have to understand there are differences and overlapping between complaints and appeal of the decision in that regard. So this is something to explore. Now, there are different jurisdictions. As you Andy say, I am French and I have been living in Ireland for over 20 years, so I know a lot about the Irish system, far too much. and also a little bit about the Northern Ireland system. The main differences is the common law and civil law jurisdiction. It's not really the most important. What's very important, the main differences, is the adversarial system. I think the adversarial system by itself is unfair, and especially unfair to unrepresented litigant, because there cannot be any equality of harm. In the UK, the civil procedure rules in the UK has been simplifying the rule of courts and uniformize them between the different courts. That's not the case in Ireland. A lot of people are talking about having legal aid, and the major case in legal aid is a case, Erie versus Ireland, was a case of a family matter where an Irish lady from Cork could not get legal aid. And the court of Strasbourg didn't recommend to give legal aid to that lady, but she suggested that she concluded that there was no effective remedy and suggested that it could be by way of legal aid that the state could solve the problem, or by simplifying the procedure, which happened in the UK by the civil procedure rule to some extent, but not such a thing in Ireland. Now, to conclude, another difference between jurisdiction, two more differences. The Mackenzie friends can be financially compensated in the UK. They cannot in Ireland. It's a criminal offense. And the last point, differences between jurisdiction, the legal cost of litigant in person can be reclaimed in the UK. I'm not sure about Northern Ireland, but about in Great Britain, but they cannot be reclaimed in Ireland so far. I will come back on that to conclude. Now, the thing I wanted to highlight, and that's what Andy asked me in the first place. It's a small presentation I made, and is to describe the different steps in proceedings. So the first step in proceeding, you have to initiate the proceedings, or if you are defending a proceeding, you have to enter a defense or an appearance in a defense. So that's the initiation of the proceedings. The second stage is the case will be listed for mention, and it's just a judge trying to see how the case is progressing. And the third thing which happens, they are called motion, and the motions are interim applications which can be heard either inter partes, where all the parties are present, or ex parte, with just one party and the judge applying for an order or relief from the judge without the other party being present. So those interim applications are issued by notice of motion when they are inter partes, or ex parte motion docket when they are ex parte. The fourth thing is the evidence. Evidence are adduced in affidavit, on affidavit, or by oral evidence. Something which is very different from the legal submissions, especially when you make legal submission in court, as they say you cannot bring evidence on your feet. So when you are making submission in court, you cannot bring new evidence during your submission. Those evidence have to be either on affidavit or have to be done by way of oral evidence or cross-examination of witnesses. So make sure that all your evidence are on affidavit before any hearing, either hearing of an interim application or of a final hearing. So the legal submission relate to the legal provisions and legal precedents which applies to the fact of the case. That's the best way to describe it. So that's the fifth point. The final point is the final hearing. And the final hearing is all about evidence, oral or written, and legal submissions. And the overall to come back on what Tony was saying about the judge who didn't want to open the affidavit, it's not for a judge to open an affidavit. It's for the party. It's when you are in court, it's you open your affidavit. Mean that you put it before the court. And there is something even worse than that. A sentence that someone called Miriam Freeman told me a long time ago. You should start by saying, I open all my affidavits, which put the judge, the courts, under duty to look at all of them. So that doesn't mean that you have to read them all, but they are open to the court.
Arno, thank you. Thank you.
The last thing, just to finish, is to come back on the stress and the stress and the mental health issue and all the consequences for litigant. And as I said, it is slightly covered in the UK and not at all in Ireland. And in that regard, I have come with a new way of putting that forward, which I would like to share, and is to add your time and trouble beside the cost or the cost of the proceedings. And your time and trouble, the way that I put this argument forward, and I invite you to add that at the end of all your applications as a relief, time and trouble and cost of an incidental to the proceedings or to the application. The purpose of that is that to vindicate your right, which is a fundamental right of yours, should not be made to the detriment of any of your other rights, i.e. your life, your mental health, or any other thing. So that's the core of it. So it's trying to create that. I have a hearing on this issue, the third hearing on this issue on the 8th of June. So if you have any question, I'm open.
Oh, no, that's all very helpful indeed. We're getting such a lot of valuable input tonight. It's a shame we haven't got that much more time left because we could spend and would like to spend much more time on these issues. I've just glanced at what Becky's just put in the chat. Becky's kindly put a link to legal advice for individuals, and it's very helpful. There's a range of other free legal services there. Arno, thank you very much indeed. Edward, you're very new
I'm
to this
posting my notes in the chat.
Thank you, sir. Thank you very much indeed, Arno. Thank you. Edward, you've got about 2 minutes to very briefly introduce yourself and explain what your organization is, and maybe we'll get you back at some stage to have a more thorough conversation with you, Edward. Please introduce yourself, Edward. Thank you.
Thank you very much. I'm very glad to be here, and thank you to everyone who's spoken. Tony, I particularly liked what you said about learning how to play the game. I think that's a really, really important thing to know because, the reality is lawyers do play games, and that's a thing that takes many, many litigants by surprise and to their detriment. So I'm the founder and CEO of Blind Justice UK. I came to this the hard way. 15 years ago, I trained as a barrister. Then life took me in another direction. I left the law for a very long time. When I came back to it, I came back to it from the other side as a litigant in person fighting my own case without representation. And what I found was a system that was not the one I had left. Legal aid had been stripped out, the courts were full of people facing them alone, and the basic administration that is supposed to hold a case together was failing. I didn't lose my case, but I saw from the inside exactly how the system fails people who walk into it alone. The files were incomplete, the process was opaque, documents went missing, and no one on the other side had any interest in putting them right. I got through it because I knew the law and because I documented everything. Most people can't do either, and I watched decent people beside me go down for the very reasons I only just survived. Here's what I think the real problem is. We are told that access to justice, the access to justice problem is that people cannot afford lawyers or that litigants in person don't understand the law. That's part of it. It is not the heart of it. The heart of it is that once you're in the system without representation, the machinery around you fails. And it fails where no one can see. Documents go missing, submissions that have been filed correctly never reach the judge. Deadlines slide by on cases that no one is really managing. And because it happens behind the scenes, the person it happens to cannot see it, cannot prove it, and is only told that they lost. No transparency, no one accountable. So in my case, I wanted to stop guessing and start measuring. So we audited dozens of case files against the court's own records. We found 92% of the cases had documents that were missing. 85% of mandatory submissions never reached the decision makers. In one case, a submission that had been filed correctly was simply never put in front of a judge, and a six-figure claim was struck out because of it. We have HMCTS admitting this kind of error in writing. And the problem is when you try to explain the same patterns repeat, the body is meant to catch this, close cases quietly, and publish almost nothing, so no one outside can tell whether the warnings were there. That's why we were on the front page of the Law Gazette yesterday asking how a regulator can close thousands of complaints before anyone has even looked at them. The Justice Select Committee has published our findings as formal evidence, and work has since reached ministers and regulators. But the research itself is only half of it. The other half is practical. So we have built a tool called Aegis. It's a legal AI specifically made for people who face the courts without a lawyer. I know we got some warnings earlier on about the importance of ensuring AI is correct, and that's exactly why we've designed and created Aegis. It assesses a case honestly, calculates the deadlines, helps people to draft court standards, and tells them plainly, and this is really important, it tells them plainly when they don't have a case. It's very difficult to tell a litigant in person they don't have a case. As a litigant in person myself, I was told that many, many times myself. You don't want to hear it, but it is important that they are told. It's not built to do the one thing that gets litigants in person into trouble, and that's invent the law. So I know what it is to sit on the wrong side of that experience alone. This is the thing I care about most, and it's why I'm glad to be in a room like this one. I'd be happy to speak to anyone else here working on access to justice
Wonderful.
and to help where I can. Thanks so much. Cheers.
Edward, thank you. Great stuff. Really great stuff. Folks, I think we're going to finish at about 7:15. If anybody needs to jump off now, of course, please feel free to do so. And you can watch the rest of it when the recording's circulated in a few days' time. Typically, that'll be out on Thursday or maybe Friday. So if you do need to jump off, that's absolutely cool. Of course it is. But if you can carry on, please do. And Becky, are you okay to stay till about 7:15? Can I have a thumbs up on that if you're okay too? It'd be great to have you with us at the end because I want to come back to you for any final comments before we finally wrap up. Yep, brilliant. Thank you very much. Let's now go to Magella, who has also got a huge amount of experience. Magella, if you don't mind, very, very quickly introduce yourself first, then put the point that you wanted to make earlier. And thank you for your patience, Magella. I know you're about to unmute, and we're going to go to Magella. Magella is also somebody who contributes to our Ireland Matters sessions. Thank you, Magella. Thank you.
Hi, good evening, everybody. Thank you for having a barrister on this evening. Thank you for having Becky on. I would just say to Becky, and barrister will pick up on this, one of the things that we need here in Ireland, or we have in Ireland, is ADR process, which is alternative dispute remedy. And that needs to be pushed more and more, particularly for people who cannot face high courts and high litigation. The one thing I would say about litigation has to be stopped. The first thing, there's no point in lay people going in trying to become barristers and trying to become pseudo solicitors in the courts. We need to build a process to give litigants tools to be able to go into the court to say, stop, I want to have an ADR process, I want a remedy, I want a resolution. Even in our mortgage arrears here, we have consumer protection laws, we've MABs, we've a whole range of services that are not effective and they cannot help us. You can go through the process of trying them. Litigation, it's like reaching for cocaine when you've got a headache and you should be taking an aspirin or taking a glass of water and and going out for fresh air. So going into litigation is like reaching for cocaine, in my view. That's the only way I can describe it. It is highly, highly dangerous, and highly dangerous for people representing themselves. And I've spent 15 years, I was taken into a plenary process and summary process for costs following probate litigation when we didn't need to be in litigation. And now I'm walking the same path through summary and plenary in the banking area, while the lawyers are able to take by default my property and other people's property. And what's happening is there's a thing in law called getting it over the line. I've been down that road, and it's done through the abuse of practice and procedures and having many hands in the pot and no one set of hands being responsible. So we have to really look at making litigants safe, not guiding them or training them to go through litigation. We have to go back to the courts. The first thing a litigant has to do is put in an appearance so that they can go in and defend to stop a judgment in default. Okay, we get that. But the next step is to take a motion to say, hey, the summary proceedings is not right for us. The barrister will appreciate I'm now going through summary debt proceedings and summary possession proceedings, the one remedy for the one debt, with two separate legal teams, highly aggressive. I told the courts recently it is manifestly egregious, and the judge got it. And I have found recently that the judges will give me everything that was in their power to give me. But when you step into the court, the first thing that's ticking is the economic interest of the court, the costs. And the second thing that's going on is the issue paper, what is before the judge, what the judge can decide on. And it's not about the truth in the court, it should be, but it's all about adversarial. And we have so much to teach our litigants that it is wrong to take them down that path. So I'm advocating for a set of tools that will get them back from the cliff. If not, you're going to have to teach them to abseil down the cliff. So we now need to put something together that will help litigants going into court to say, look, pause the clock, stop. I asked the other day, I told the court I was being rushed through. They've paused it. They give me time to bring extra motions. I have to continue litigating in order to try and get out of it. But I've told the courts I want to mitigate, not litigate. And the banks have not afforded us the resolution processes that we're entitled to before bringing on litigation. Now, we have a whole political thing going on as well. And I think a lot of the time the judges' hands are tied, and judges are fed up to the back teeth with litigants coming in who don't know what they're doing. And the judges can see that they're going down the wrong avenue, and they can't just give them the time to do that. So they cut them short and get them thrown out. We also have, again, we have a lot of JAs, which are judicial assistants, reading the papers for judges, and with the backlog building up and litigants not being able to follow the process and follow the timelines, it's creating problems in-house. But if you know your way to navigate through it, you'll get a little further. But I'm saying to you loud and clear, stop litigation. Make citizens safe. That's the whole way out of it. If not, we can talk about tricks and practice and procedures till the cows come home, and we may as well go off and take legal courses. And people don't have time for that.
Magella, as always, thank you so much for the points you make. It's very helpful. It is very helpful indeed. Hopefully to see you at the next at tomorrow's Ireland Matters meeting, Magella. Thank you, Magella.
Thank you.
We're going to go to Lisa King briefly, then we'll go to Heather briefly, then we'll go to Mark Bannister briefly, then we'll go back to Becky for any final comments from Becky before we wrap up at about 7:15. But thanks everybody so far. You know what? I'll tell you what I'm thinking. We could run this session once a month and we still have stuff to talk about. We really could. There's always more to learn. And if we can help people when they're in that pressurized, stressy state of having to go to court to potentially defend their home from repossession or their life savings that's been stolen from a fraudster or by a fraudster, or taking on a great big bank. I mean, let's try to do what we can to help. Lisa King, your thoughts, please. Thank you.
Hi, everyone. Mine is quite an ongoing case. Andy was kind enough to come to court with me last March.
Wow.
It's been going on a long time. In between that, I had a serious accident, but I am seriously ill and I suffer. I'm seriously ill. I don't know, need to go anymore. I'm seriously ill. I've made the court aware. The bank, Lloyd's Banking Group, is fully aware too. So that's just a little bit of background for everybody. Edward, if you want to know a case that would make your jaw drop to the ground, I'm happy to share my details with you. Andy knows my case, but the point I want to make about what's been going on is I had to file a N244 to get the bank to disclose a DSAR to me. Now, the DSAR is about my late husband The mortgage was solely in his name, and it's proving to be very difficult. So on the 6th of April, I submitted a N244 application. The case was listed for the 27th of April. The claimant was made aware of it. Their barrister TLT was made aware of it. So I filed it. Everything was in there that I needed to do. I had help from somebody who guided me through how to fill out the form, what to ask for, and everything. So I was gearing myself up for that hearing on the 27th of April. It was a remote hearing because I said I'm severely disabled and I suffer with a serious illness. So I was geared up with that. I'd gone through everything I was going to say to the judge and everything. On the Friday, the 24th of April at 6:36, TLT dropped a response to the N244 application. That meant that on the Monday, the 27th of April, I had to file my response to their response. So the judge looks at everything. She says the court hearing starts, and the judge says that she was only handed everything the hearing was at 2 o'clock. She said she was only handed everything at 1:33. She's not had time to go through everything. She then looked at me and said that I was at fault for filing my response to the claimant on the Monday morning of the hearing. She attacked me from being the one in the wrong. I was a bit taken back by that, and I pointed out to her that the only reason I had to file a response was because the claimant had filed at 6:36 p.m. on the Friday the 24th, way after the court had closed. And it should have been filed 2 days before the hearing anyway. And she didn't realise that, but she didn't apologise to me. She attacked me straight away as the litigant in person that I was at fault when I wasn't. Anyway, she said she couldn't go through it because she hasn't had time to go through it. So it got moved to the 7th of May. So on the 7th of May, again, I had prepared myself for a remote hearing to go through what my N244 application was. And it was simply for the bank to disclose to me information that I am entitled to. Nothing more than that. I had filed everything on time leading up to that, even a witness statement, everything. And the judge, oh, sorry, I'll condense it down. Sorry, I know lots of people want to talk.
Thank you, Lisa.
So my point was, on the 7th of May, my N244 application got struck out. But my point to this meeting today is, straight away, the litigant in person, was attacked for being wrong and doing stuff wrong when it had nothing to do with me at all. That's my point. Sorry for going on a bit. I know you're right for time.
Don't apologise. I think you've made some really important points here. It seems like our system's failing. It's not functioning the way it's meant to. Lisa, thank you for taking time to share that. And I know it's not easy to share it as well. And obviously, Lisa, as you know, we all wish you the best of luck with your case. Heather, I'm going to have to ask you, squeeze it into 2 minutes, please. And Mark, squeeze it into 2 minutes. Then we'll go back to Becky. Heather, up to 2 minutes, please. Thank you.
Yeah, thank you. It's a good segue, actually, because it's about the discrimination against litigants in person, tying in AI. So on the 18th of June, if anybody's free, in London, I shall be in court with an application in relation to a judge who used AI to attempt to prematurely dispose of an interlocutory appeal. And I'll just leave this with you. In terms of AI, and pattern recognition. AI models are trained on vast data sets of judgments where professionals are given the benefit of the doubt and LIPs are held to strict procedural standards. So that's very much the how litigants in person are held to account whilst the professionals are not. And it's this misuse of AI. It's very, very concerning. So if anybody is available, that's another thing I was going to say, is to support each other.
Yeah.
To be a fly on the wall in the courtroom is, if
Very
they
helpful indeed. Yeah.
have a dozen pairs of eyeballs or a dozen eyeballs staring at them, they're going to get away with less.
Heather, thank you. That's really helpful. I'd like you, please, Heather, to put the details of the upcoming hearing in the chat so folks who want to go to it or want to contact you about it can. So please do pop the details in the chat, Heather. You know what? AI gets so many different points of view. We're going to go from your point of view about AI to Mark Bannister's, no doubt. Mr. Mark Bannister, please do share your thoughts. I'm sorry to ask you to squeeze this into 2 minutes or less, Mark, but I know you can do it. Go for it, sir.
I'm not going to speak about my case, but everything that Edward spoke and said, and everything that Tony said applies to me, and I suspect applies to everybody. So my key point to everybody here is this is a broken system. We should not apologize for it. We should do what Edward has obviously started by doing and point that out remorselessly until people listen to us. In fact, I would go so far as to say we should cease to engage with it. And if enough of us do that, then I suspect the system will collapse under its own weight. We must make sure that the people who are at the top of the system, the people in the appeal court, the Supreme Court, recognize that what they are actually doing is protecting a system that does not function. At the bottom end, it's an injustice, and it's an abhorrent injustice. It just hasn't got the mechanisms that it needs to have. And we as litigants in person should be able to function within that system assuredly, not be victims of it as we are. And that's before you get to your case. And that is my grave concern. And I think we need, Andy, I know you've got the financial side that you're dealing with, but we've got to put this in front of all the legislators. And I have a very, very simple way of doing it. We should invite 50 MPs to become litigants in person in cases that they've got to run up to speed, do all the paperwork, submit all the things, and then go and litigate in front of a professional barrister. And they will get slaughtered, every damned one of them.
Absolutely.
Now, at that point, they cannot be, because ultimately Parliament is in fact the primary place for all it's the highest court we have. Parliament needs to understand, and the people who operate within it, if they can't make it work, how the hell do they think anybody else does?
Well said, Mark. Really, really, really well said. Some of you don't know Mark at all. I really do vouch for the if you like the evidence base upon which Mark has made his comments is really pretty rock solid, unbelievably so. Mark, thank you. Becky, you've triggered such a great conversation here tonight. So, Becky, please do share any final comments you'd like to make before I formally bring tonight's event to conclusion. But the overall thought I'm coming away from is we need to carry on running these events. We really do. Becky, please do share your final thoughts. Thank you.
I think it's been really interesting, just some of the complex cases that the group is having to face, that's ongoing, that I might not completely understand in terms of the case background, but something that has come across is the frustration that those that are going through this experience feel, and the fact that there isn't enough support or even insight in terms of just an understanding. Maybe we could have a look at from a judicial perspective, even to try and manage people's expectations, but certainly again, it was really interesting to hear Edward speak in terms of the work he's doing with his organisation. So it'd be good to potentially get some information. So perhaps we could effectively signpost to your organisation, Edward, and I'll certainly. I appreciate being asked to speak today, and if there's any further support I can provide, Andy, please just let me know. Thank you.
Fantastic. I'm just putting a note in the chat. I'm going to ask Becky. I'm going to ask Alexandra to connect you, Becky, with Edward. I'm sure there's a healthy Venn diagram overlap between your interests. You're complementary but not competing. That's how I kind of see it. You're doing two slightly different things. So I think there could be a good, a good working relationship there between you, as you've indicated, Becky. And I just saw Edward nod his head. So please let me just finish this little note to Alexandra. Alexandra, please connect Becky and Edward by email. Okay, my sort of very final thoughts about this session. Litigants in person are up against it by definition. They are effectively having to go into battle with their hands tied. And they're going into battle often with an enemy who they'd struggle to defeat, even if they didn't have their hands tied. So as a society, we really ought to do all we can to try to help litigants in person. Some people have got knowledge, insight, wisdom, experience, ideas, vision that's of great value to others. And Becky's shared her knowledge, insight, wisdom tonight. So has Tony, so has Arno, so has Edward, so has Magella, so has Mark, so others as well, so has Heather. This is what we need to do, folks. We need to share insights and wisdom with each other. We need to weaponize each other's arguments and capabilities in the judicial process with knowledge. They say that knowledge is power. I don't think that's strictly true. I think knowledge is power when applied. And by learning from each other in this way, we can learn how to apply that knowledge. Thank you all so much for what I believe has been a very helpful meeting. Alexandra will share the chat. Alexandra will organize the recording. Please share the recording on social media. Let's get the word out there. And thank you all very much indeed for investing some time on this topic tonight. Thank you all very, very much indeed. And we'll wrap it up there. Thank you all very much.